So hi, everyone. Welcome. My name is Travis Champion with Investorcom, and we're delighted that you were joining us today for a conversation on Reg BI and the DOL rollover requirements. A few housekeeping items before we get started. We are recording today's conversation and plan to share it with you following the session. Next slide. We hope this is an engaging conversation, and we welcome that engagement and your questions. So please use the chat box at the bottom of your screen and submit questions for our panelists. We have a lot of time near the end of the session today to address those questions. And as with many of you, we're all also working from home, so you may hear some background noise. We appreciate your understanding in that as well. Next slide. So to get us started, I'm going to ask our panelists to introduce themselves, starting with Carol. Carol.
Thank you. I'm Carol McClarnon. I'm an ERISA partner in the Washington office of Eversheds Sutherland, and I focus my practice on ERISA compliance for financial services companies and other plan service providers.
And I'm Issa Hanna, also at Eversheds Sutherland. I'm a counsel in our New York office, sitting on our broker-dealer, investment advisor, regulatory team. I work with broker-dealers and investment advisors of all shapes and sizes on compliance issues, but over the last several years, I've been spending a lot of time working with my clients on compliance with the various standards of conduct that are evolving in this space, and in particular with respect to Reg BI and the Advisors Act fiduciary duty, and also a bit with respect to the NAIC model changes that have been going on with respect to annuity suitability transactions under the state insurance laws. So happy to be here today, and thanks to Investorcom for having us.
Issa, Carol, thank you very much for your time, and thank you for joining us today. My name is Fiduciary, VP of Regulatory Strategy at Investorcom. We're delighted to bring together today's conversation. As Travis said, we've got a large audience to engage with, and please remember to send your questions in through the chat box. Okay, with introductions aside, let's jump into the conversation, seeing that we're 2 minutes in, and let's begin with some poll questions. First, we want to know how prepared are you to meet the DOL's PTE 2020 or to rollover requirements? And also, how do you plan to meet the rollover requirements? So let the polling begin. This is looking great. I love it when there's a large number of responses, because you can just literally see these ratios swing wildly. Let's give that one more minute. Thanks, Karen. Let's now share the results just to see what they look like. Okay, so on the question of how prepared you are to meet these requirements, there's about 11% who are ready. Most, or the greater majority, are almost there, which is a positive sign. And thank you for engaging us on today's conversation. Hopefully, we can get you closer to the filing signs, and then some, if not sort of the second most number of votes, indicate that folks are just getting started. And hopefully we are able to provide some helpful insights through our conversation today. Now, on the question of how do you plan to meet the rollover requirements, some folks are going to be adopting technology, while others are going to, 66 of the votes here, or 44%, they plan to update their process and procedures. And some folks are just planning not to do none of the above, or 5%. So I'm going to share those quickly if you haven't seen them already. And we will be sure to share these with you as well after today's conversation. Okay, so I'll stop sharing those results and get out of this polling piece. Again, I already see some questions coming in, so thank you. We've definitely allotted a chunk of time to tackle these near the end of today's session. So to get us started, let's talk about what's going to be on the agenda today. So first, we're going to start with a backgrounder around what are the developments and timelines of the rollover requirements. And we're going to take a look at the emerging issues around sort of the specifics on the SEC and the DOL's rollover requirements. And then we'll talk a little bit more about the compliance priorities, given the timelines that are on the horizon. And as we've chatted earlier, we've got a chunk of time allotted for questions throughout today's conversation. So, Issa, let's begin the conversation with a bit of a backgrounder for folks who are possibly less familiar with the concept of rollovers and why are they important to investors, financial professionals, and regulators.
Sure, happy to take that question. So I think the place to go to get an understanding of, I think, the SEC's thinking on this issue, where they're coming from, why they're deciding to focus so much on rollover recommendations, is the Reg BI adopting release. And a number of you may be familiar with the fact that Reg BI, in a way, was a game changer, especially with respect to how it applied the broker-dealer standard of conduct to more, and I guess different types of investment strategies. And one of the investment strategies that Reg BI now applies to is a rollover recommendation. Under the prior FINRA suitability regime, there was a regulatory notice out there, Regulatory Notice 1345, that talked about how a broker-dealer could meet its general standard of conduct obligations with respect to rollover transactions. But under the old FINRA rules, it was never contemplated that a rollover recommendation was within the definition of investment strategy. When the SEC adopted Reg BI, that changed, and there is now an explicit requirement to subject a rollover recommendation standing alone to Reg BI standard of conduct, that best interest obligation in general. In terms of why the SEC decided to do that, they cited a number of policy considerations that they believe justify this expansion of the broker-dealer standard of conduct to cover rollover recommendations. So they listed a number of things. First, they said that rollover recommendations are frequently provided at a critical juncture in an investor's life at retirement and are often irrevocable decisions. So the fact that the decision can't be undone and it happens at a critical juncture in a retail investor's investing history, those are important considerations. They also said that decisions about which type of account to open have the potential to greatly affect a retail customer's cost, and that both rollovers and account type recommendations can have substantial potential long-term impacts on investors, particularly associated with cost. So, the particular account type or the particular IRA that somebody rolls over into could have significant cost consequences for somebody on a continuous and recurring basis. Next, they said that retirees have no practical ability to recoup lost spending power by returning to work and setting aside additional retirement savings. So if somebody receives a bad rollover recommendation, they have no way to go back to work, save more money, and make up for it. And then finally, they say that these policy considerations are in direct tension with a strong economic incentive that broker-dealers and investment advisors alike have to recommend that investors roll over plan assets into an IRA or otherwise transfer assets to open an account with a broker dealer or investment advisor. So you take all these different things together, and the SEC says we have a strong interest here in really regulating these recommendations vigorously. So that's where the regulators really are coming from.
Thanks, Issa. So let me ask this, for folks who are maybe potentially less familiar with the holistic advice or holistic concept of rollover advice, why are rollovers in aggregate? What are the drivers that are sort of resulting to rollovers being a point of regulatory scrutiny?
So, I think it's just it's a function of two things. In addition to the policy considerations that I mentioned above, I mean, from the perspective of just how certain trends in our country are kind of playing out, those things I think are also informing the regulatory strategy here. So we have a substantial population of investors that are coming of age, so to speak, are approaching retirement, the baby boomer generation. There's a lot of dollars that they are having to make a decision with respect to. And there's been just a long-term shift in the way that folks have invested and managed their retirement assets over time. There has been a long shift from a pension system in this country to an individual defined contribution type system in this country. So you factor in those kind of long-term trends, and also consider the policy drivers that I mentioned in response to the last question, and you see why there's so much attention on this particular issue.
And just to jump in and add to what Issa said, I mean, these are the exact reasons that have been behind the DOL's fiduciary rule, the various iterations of it over the years. The original definition of an investment advice fiduciary for DOL purposes goes back again to this concept of when ERISA first came into play, and there were a lot of the defined benefit pension plans. And so the investment advisor was really the advisor to the trustee of the pension plan and giving them advice on a regular basis. And one of the reasons, or the prime reason, why DOL has been so vocal about wanting to change the definition of fiduciary is because of these same issues that Issa pointed out. Namely, we've moved from a defined benefit to a defined contribution system. Participants are more in charge, they're bearing more of the risk and more in charge of the investment decisions. And DOL has cited that as a reason for the changes that they've been making and proposing over the last few years.
That's really helpful. Thank you. So we now understand sort of the background or the conceptual background for what rollovers are, why are they important, and sort of why are they under scrutiny from a regulatory perspective, whether you talk about it from a DOL or SEC perspective. And that with sort of the specifics on the slides here, let's zoom in on the SEC's focus on rollovers from a best interest perspective. Issa, maybe you can share a little bit with us what's absolutely required from a compliance perspective, and what's been the SEC's focus in the past 6 months or so around rollover recommendations.
Sure. So, I mean, I think when you look at Reg BI, what a lot of folks tend to zoom in on right now is compliance with the care obligation under Reg BI. That's where the examiners have been focusing their efforts, and where a lot of industry participants have been focusing their efforts as well. And just in terms of what the SEC has stated are the particular requirements when making a rollover recommendation to comply with the care obligation. First, they say that as a fundamental matter, you should comply with the general requirements applicable to any account type recommendation or any investment strategy recommendation. So from a general perspective, they say that when trying to determine whether an account type recommendation is in a particular retail customer's best interest, broker-dealers generally have to consider 5 points: the services or products provided in the account, the projected cost to the retail customer of the account, alternative account types that are available, the services requested by the retail customer, and the retail customer's investment profile. So those are the 5 things you have to consider to meet that customer-specific component of the care obligation, just from a general perspective. Then they focus on rollover recommendations and provide specific guidance about what needs to be taken into consideration when making a rollover recommendation in particular. And then they say, in addition to those general factors that I listed before, they say that when suggesting or recommending an IRA rollover, a broker-dealer has to consider fees and expenses, level of services available, available investment options, the ability to take penalty-free withdrawals, the application of any required minimum distribution requirements, protection from creditors and legal judgments, holdings of employer stock, and any special features of the existing account. Then they make a couple of other points as they kind of wrap up the discussion. First thing they say as a wrap-up point is that you cannot, as a broker-dealer, point to the availability of more investment options as the sole basis for recommending a rollover. Just saying that that's the basis for your rollover recommendation is not enough. There has to be more to it than that. The availability of investment options alone is not sufficient. And then the final thing they say is that as a best practice, they suggest that broker-dealers document the basis for a rollover recommendation. Not an explicit requirement, but they suggest as a best practice, given the sensitivity associated with these recommendations, that broker-dealers turn to that process. Now, there's a difference between the Reg BI regime and the DOL regime on that point, but that's something that they specifically call out in the Reg BI adopting release. So, Parm, I guess I'll turn it over back to you.
Thanks, Issa. That's a very thorough explanation. Appreciate that. So, given that the SEC's requirements around rollover recommendations, we don't have to really look too far back to check the temperature on this particular issue. Recently, there was a significant enforcement action around, and there was a fine or settlement around $100 million brought by the SEC and the New York Attorney General's office. Can you share a little bit of insight around what that enforcement action was about and what can we learn from it?
Sure. I think the overall lesson from that enforcement action is that you shouldn't discount the other pieces associated with a rollover recommendation beyond just compliance with your care obligation if you're a broker dealer, or your duty of care if you're an investment advisor. And by the way, the action that Parm was referring to was brought actually against an investment advisor for violations of the Advisors Act. It was brought under the Advisors Act fiduciary duty. But I think there are lessons there for all industry participants. What the SEC and the New York Attorney General pointed to in this case were disclosure issues and conflict of interest management issues that ultimately impacted recommendations. From the disclosure perspective, this particular investment advisor had disclosures that the SEC and the New York Attorney General found misleading, in that they said that recommendations of rollovers into a managed account program were objective, involved no variable compensation, et cetera, when the supposed, incentive compensation arrangements that this investment advisor had actually made those statements untrue. So there was an issue with the conflicts that were associated with the program, certain incentive compensation arrangements that were not properly disclosed and were actually disclosed in a way that obscured the conflicts. And then, just a couple of points here for investment advisors that I thought were interesting. In this case, the SEC actually extended the fiduciary duty to the rollover recommendation itself, not just the advice that was provided in connection with the managed account, which I found interesting given the guidance that appears in the 2019 Investment Advisor Fiduciary Duty Adopting Release, which makes a distinction between advice that's provided to roll over and advice that's provided after somebody becomes a client. Generally speaking, the SEC says that really it's just anti-fraud obligations that apply to a recommendation to roll over. But in this case, given representations that were made by this investment advisor, that it was providing a holistic financial planning solution that covered the rollover advice, the SEC found that the fiduciary duty actually attached to the rollover recommendation. And the second thing that I found interesting about this action, and to just wrap up here, was that the SEC found that because this advisor had adopted policies and procedures voluntarily, requiring itself to document a discussion or the results of a discussion, any discussion that somebody had or that an investment advisor representative had with the individual prospective client about fees, they in effect had an obligation to document that fee discussion and effectively the basis for the recommendation. So, while under the Advisors Act, there's not necessarily an explicit requirement to document the basis for recommendations, the SEC came down on this advisor for not documenting the basis for these recommendations on the basis of them having policies and procedures that otherwise require them to do so.
Thanks, Issa. So let's now actually turn the page a little bit and focus on the DOL specific requirements. And I know, Carol, from having chatted about this earlier, there's probably a little bit of a history lesson that's required here. If we were to sort of look at the DOL's requirements and sort of say, let's start from where it started and where we are today. Do you have any insights to share with our audience?
Sure. I think we're, like we mentioned earlier, the way this is really what's behind all of the DOL work is to try to take some old statutes and old regulations, well, old being the 1970s, and kind of convert that into today's world. And the DOL is really looking for a way to regulate the whole rollover process. And what's been tricky for the DOL is the test for who is a fiduciary, because DOL can only get to this once the advisor or whoever it is considered an ERISA fiduciary or a fiduciary under the Internal Revenue Code, which has the same definition. And the way that they do this is really through the definition of an investment advice fiduciary. So if we go back to before 2020, I'm sure everybody on this call has memories of trying to comply with the second version of the fiduciary rule that the DOL put out. And as most of you know, or all of you know, that rule was vacated by the Court of Appeals. So in 2020, the DOL proposed and adopted a new fiduciary rule. And by that, there are two parts to it. There is a definition of who is a fiduciary, and then there is a prohibited transaction exemption. And we'll get into it in a minute, what that means. And they were not able, in 2020, they did not change the definition of fiduciary as they had previously. Instead, what they did is announce a reinterpretation of what it means to provide advice on a regular basis. And what the DOL said was that rollover advice, that could be the first step in an ongoing relationship. Or you could, it could be somewhere in the middle. You might have an advisor who has not been providing rollover or advice to the plan, to the participants assets in the plan, but is otherwise a financial advisor. And once they begin talking about rollovers, that would be kind of incorporated into that regular basis. And so that's where they got how rollovers got pulled into the mix, because when you think of just a rollover, that's a one-time advice. And so when you have a regular basis test, they had to come up with a way to get to it. Getting into 2021, on February 12th, we were surprised that the new administration said it was going to go ahead and allow this rule to take effect as scheduled. I think everybody in the industry pretty much thought it was going to be scrapped. What this did is, as of February 16th, the new interpretation of who was a fiduciary went into effect. What the DOL has done is say, up until December 20th of 2021, which was a transition period that was already there for compliance with the Rule 3.0, up until that date, it's a good faith interpretation of any kind of prohibited transaction relief that might be needed. But the definition of fiduciary with respect to rollovers is in effect now. So we started to go along and deal with that. And April 13th, we got some FAQs that came out. And the quote that is up here in the FAQs is what's important. And that is that the department is reviewing issues of fact, law, and policy related to the PTE, and that they anticipate taking further regulatory and sub-regulatory actions as appropriate. And I think that's what threw everybody for a loop. So we had clients that were, okay, I guess we've got to deal with this new rule and we'll start getting ready. And then this FAQ came out and it kind of stopped everybody in their tracks. So I was not surprised to see the poll results that only 11% felt like they were completely there yet, because this caused a lot of confusion. We do have a proposed rule that has not been announced yet, but it's been put on the calendar. And that's what's over here on the right side. And this really tells you that, gives you a hint as to what's going to happen in December, which is a redefinition of fiduciary, which will bring in rollovers a little more clearly than what they felt they could do with this interpretation, and that there will be changes to both PTE 2020-02 and some changes to existing prohibited transaction exemptions. So there are some, like insurance companies, for instance, have a different prohibited transaction exemption that would be available to them, PTE 8424, and that exemption has it's a lot less onerous to comply with than 2020-02 would be. And the DOL has gone out and said, well, we're probably gonna change that a little bit. So we're at a point where we have to be in compliance by December 20th, but we're not exactly sure how long that compliance structure is going to be valid and how long it's going to work. And we don't know what's going to happen after that and whether that compliance solution will still be effective.
Wow, Carol, thank you. You I don't know how you managed to kind of recite and give us a nice sort of a history lesson on that, but you certainly did a great job. Let me kind of, I fumbled saying PTE 2020-02 in the outset. I'm probably one of many who's sort of misquoted that term. How does can you kind of give us a backdrop of what exactly is the prohibited transaction exemption?
Absolutely. For those of you who don't deal with ERISA on a regular basis, it often comes as a surprise that ERISA is a little bit backwards in how it's set up, in the sense that almost everything is a prohibited transaction unless. So you have two sets of prohibited transaction, and the set that involves conflict of interest is just applicable to fiduciary. So the first kind of step is you have to determine whether or not you're a fiduciary. And up until the rule changes that from the DOL, pretty much rollover advice. That was not a regular basis. So you were not a fiduciary as defined in ERISA, and you really, that was the end of the story. You didn't really have to think anymore. Now, if you determine under this new interpretation or whatever this Rule 4.0 is going to look like, that hopefully we'll see in December, if at that point you determine there are concerns that you're a fiduciary, then you have to worry about these conflict of interest prohibited transactions. And what those really, in essence, mean is if you are a fiduciary, you are not allowed to use your fiduciary authority to cause yourself to get additional compensation. That's really what's going on. And so once you decide, okay, I'm a fiduciary, and then you have a transaction like the rollover transaction where the DOL's position is, if the person says no to the rollover advice, you don't get paid. But if the person says yes, then you do get paid. And so the DOL is saying that's your exercise of your authority that causes yourself to get paid additional compensation. So at that point, you have to look for a prohibited transaction exemption. And as I mentioned, 8424 before, that's specific to the sale of insurance and annuity contracts, but there are other different types of transactional exemptions. And PTE 2020-02 is a broad-based exemption that is based on compensation. It covers the compensation paid, no matter the form, no matter the type of transaction. And so for a lot of different, if you don't have a specific 8424 type of exemption that's available to you, then you need to go to 2020-02. And the way an exemption works is if you meet all of the conditions of the exemption, then the transaction at issue is not a prohibited transaction. So it's a little bit backwards. It's not a rule that just because you have a retirement plan, you have to do all X, Y, and Z. It's more, I don't want to violate ERISA, so I'm going to take these steps so I fit within an exemption.
Wow, Carol, thank you again. That was fantastic. Now, you've kind of explained it in a sort of a reverse psychology perspective of saying, hey, this is how you qualify for these particular exemptions. The other question that comes to mind is more around jurisdiction. Mm-hmm. And if somebody out there in the wealth management world were to make a rollover recommendation, who has jurisdiction from a regulatory perspective?
From the DOL's perspective, the way that the DOL views that rollover recommendation is that at the time the recommendation is made, that money is still in a retirement plan, and that retirement plan is subject to ERISA. So the DOL is saying we have jurisdiction because you're providing investment advice for a fee with respect to a retirement plan. Once it gets over into an IRA, or if we're talking about IRA to IRA types of transfers and rollovers, then the DOL no longer has enforcement jurisdiction. That goes to the Internal Revenue Code, where there's an excise tax for prohibited transactions. But the DOL does have interpretive authority over the prohibited transaction sections of the Internal Revenue Code. So even though it can't enforce anything once it gets over to the IRA, whatever rules and definitions and exemptions that DOL comes up with on the ERISA side are going to apply on the IRA side. And just the analysis there is, if I have a prohibited transaction under the code and I meet the exemption, then I don't get an excise tax on the transaction.
Got it.
And
Go
from
ahead.
from the perspective of other regulators, the SEC would say that if you're a broker dealer making a rollover or account type recommendation of any kind, even if the recommendation does not involve the recommendation to purchase a particular security, that investment strategy recommendation alone triggers the requirements of Reg BI. So they would say that from a broker dealer perspective. From an Advisors Act perspective, the SEC would say that they have jurisdiction with respect to an advisor recommending a rollover transaction, at least based on the anti-fraud requirements of the Advisors Act, but based on this case that we were speaking about earlier, could also you could also have a situation where the fiduciary duty under the Advisors Act, under Section 206 of the Advisors Act, applies to that recommendation, depending on the representations that have been made to the client about whether the advice about the rollover transaction is part and parcel of the advisory relationship. So that's, you know, the SEC perspective on this.
Excellent. Okay, so we've had a really, really good and detailed conversation around what the specifics of the requirements are and what each regulatory organization, if I could call them that, tends to expect from folks who want to make rollover recommendations. Now, let's turn the page and talk about differences, because that's a good way of establishing what the requirements are going to be. And maybe we can start there. Issa and Carol, what are the specific sort of deltas between the specific regulations when making rollover recommendations?
So I'll start from an SEC perspective under Reg BI. So a significant, I think, difference between the Reg BI regime and the DOL regime is this notion of regular basis under the DOL regime, not really kind of arising under Reg BI. Under Reg BI, a single rollover recommendation, a recommendation of a single investment strategy, gives rise to that best interest obligation. And then, kind of speaking to this concept that Carol mentioned earlier, it's I guess not as counterintuitive under Reg BI. From the securities law perspective, you start from the assumption that collecting a fee on a recommendation or some kind of investment advice is permitted, and then there may be certain requirements you have to comply with along the way. You don't start from the presumption that everything is prohibited and have to find an exemption under the federal securities laws. Carol, did you want to pick up from there?
Sure. Right, as I explained before, there's this regular basis component, and the DOL has gone out with a very, very broad interpretation that's in effect now about what they think regular basis means. What I anticipate happening in December when we get Rule 4.0 is that the regular basis piece gets dropped. That's what they've done in the other iterations, and the DOL, when people from the DOL are out speaking, it's clear that they feel that the regular basis is a huge loophole in the investment advice fiduciary definition. So, once that's gone, then we would be in the same place as Issa explained with Reg BI. But as of now, it has to be part of this, regular fiduciary relationship.
One other thing I'll mention is that from just a scope perspective, aside from the regular basis, consideration under the DOL's rule, the DOL rule applies to more, types of, intermediaries. It's not just broker dealers like it is under Reg BI. It's really anybody making a recommendation that is captured by the rule. And Carol, did you want to speak to that a little bit more?
Sure. No, that's really an excellent point, Issa. Part of the controversy with PTE 2020-02 is, and I think we'll probably speak to this in a little bit later on the program, is this fiduciary acknowledgement concept. So what you end up with, remember I went back and said everything's prohibited unless it's not. To take advantage of this particular exemption, you have to acknowledge that you're a fiduciary, whether you are one or not. So that kind of brings in, fiduciary standards of conduct where they were not, at least when ERISA was first written, intended to be there. And that's part of why the last version of the rule got thrown out. Was this contractual taking on contractual fiduciary responsibilities. Now, the PTE here does not have that best interest contract, and the DOL has been on record as saying we're not going to require that, but query whether putting that in writing, whether or not you've got a contract or not, isn't kind of amounting to the same thing at the end of the day, where you're happy to say you're a fiduciary when you're not. And that goes up to the intermediary ends too. And this is something particularly in the insurance industry that's been a big struggle, is the concept of who is the financial institution, because under PTE 2020-02, it's not just the person giving it advice that has to say they're a fiduciary. It's also the financial institution that the advisor is associated with. So you have situations where insurance companies, just because they've created an annuity contract as a product manufacturer, are struggling with, well, how do I say I'm a fiduciary? Because the intermediaries who would be supervising the advisor are not eligible to be listed as financial institutions. So we get into a lot of confusion on this point. And, something that I know Issa and I have talked about a lot and talking with our clients is, what do you do in a situation where you have a broker dealer who's not allowed to say they're a fiduciary under securities laws, having to come out to comply with the prohibited transaction exemption and state that they're a fiduciary? There's a lot of tension in that. And
yeah. It's a delicate dance. I mean,
it is.
Yeah, I mean, you have to be very careful about saying that you're only a fiduciary for purposes of ERISA, and that on the broker-dealer side of the coin, you're not a fiduciary and you're held to a broker-dealer best interest standard of conduct. Whether a retail customer is going to understand any of that or be able to make sense of that, I am not particularly optimistic. But that's the dance you have to do, I think, to comply with the miscellaneous requirements here. And it's interesting because the SEC has also been very insistent upon the use of particular language in certain disclosures. So I have some clients who decided that the Form CRS stock disclosure around standard of conduct was not accurate with respect to their investment advisory services. And I think they had a good argument for that. They said that when they act in an investment advisory capacity, that the SEC's Form CRS instructions, which say that, investment advisors have to say that they're held to a best interest standard of conduct, they thought that that wasn't accurate. They thought that, investment advisors are actually held to a fiduciary standard of conduct under Section 206 of the Advisors Act. And they took liberties with the language in their Form CRS and said that when we act in an investment advisory capacity, we're held to a fiduciary standard of conduct. And the SEC came back and said, no, you have to use this best interest language. You have to use the language, the exact formulation of the language that's contained in the Form CRS instructions. So, if you're looking to make use of your Form CRS to accomplish your, ERISA fiduciary disclosure goals, you're going to run into that roadblock where, you're potentially kind of creating regulatory exposure for yourself with the SEC, who says, you have to stick to our prescribed language under the Form CRS, and you can't call yourself a fiduciary. You have to say that you're held to a best interest standard of conduct across the board.
This is particularly interesting because as you go through this, with respect to kind of the FAQs as well that have been outlined, as I read them, when you're making when a financial professional makes a rollover recommendation, they also have to outline why that recommendation specifically is in the client's best interest. So the rationale of the recommendation. Any advice or any sort of insights on how, whether to sort of lean on boilerplate text when it comes to disclosure or try to customize that to this individual client specific needs?
From my perspective, the the documentation was with the proposal, and so that was vetted through the notice and comment process. But the piece about providing the rationale, disclosing that to the participant, that's new, and that came in with the final PTE. It wasn't there at the beginning, so we don't have a lot of background. If you read the preamble to the PTE, it states that commenter suggested to the DOL that they should be requiring this to go to the participant, and DOL said, good idea, and they added it to the rule. We don't have a lot of color as to what needs to be part of that disclosure. I don't know that it necessarily has to be the same as whatever checklist or system that you have that you're doing for internal purposes. So what I have seen people doing is if they have checklists or different types of rollover notices that they're already using, they're just kind of marking that up a little bit. But right now we don't have a lot of specifics as to what has to be in the customer piece of that.
Yeah, I mean, I'll mention a couple of things here from a Reg BI perspective. So, from the perspective of documenting the basis of the recommendation and disclosing it to retail customers, there's no explicit requirement under Reg BI to do that per se, but it is being encouraged as a best practice. And if you've been through a Reg BI 1.0 or 2.0 exam to date, you've probably run into this issue with the examiners where they have asked for your policies and procedures relating to rollover recommendations, and perhaps you run into some tough questions about what you're doing to record the basis for it. I've had some clients who have told the SEC examiners that they feel like they're in a good spot from a rollover documentation and disclosure perspective, because they've decided to keep certain processes that they implemented from the 2016 DOL rule, the 2.0 iteration, as Carol likes to call it. I've actually seen those clients get pushback from the SEC staff and say, well, that's great, but the DOL rule 2.0 is not Reg BI. What have you done specifically to tailor this, this disclosure and basis for recommendation form to the specific requirements of Reg BI? And what they really key in on is this notion of cost, the cost comparison issue. So if your process from the DOL days does not include a robust comparison of costs, the SEC staff comes back and says, well, this is not Reg BI compliant. And what I've heard from top SEC staffers at the SEC, and I've heard this on numerous occasions, is that they really are looking for actual costs whenever possible, actual cost comparisons between the existing workplace retirement plan that's currently holding the assets and the proposed rollover, IRA account. And whenever that information is truly not available, because, for example, the existing workplace retirement plan is not willing to provide it, or the participant is not able to obtain it, and there's no reasonable way to get it, the SEC staff that have made public comments to this effect have said that it might be reasonable to rely on estimates or benchmarks, but I think they're really looking for actual cost comparisons whenever possible. Now, that's not a specific requirement outlined in Reg BI, in the adopting release, in any of the FAQ guidance that's come out to date. That's a top-level SEC staffer opinion, I guess you could say, and they'll always preface these opinions with statements to the effect of this is my view, this is not the SEC's view. But I think you have to at least kind of acknowledge that the remarks and try to come into compliance with that standard if at all possible.
Excellent. So Issa and Carol, thank you. Those were sort of our planned conversation pieces. I know we've allotted time for Q&A. So, but before we pass it over to, we look at the Q&A session, let me pass it over to Travis for some concluding remarks. Travis?
Yeah, thanks, guys. Issa, Carol, Param, good stuff, and I can't wait to hear the rest based on the questions received. But I did want to say, in keeping with our theme and our goal of bringing the experts to the table and providing value to the community when it comes to this, as always, our goal is to get you and your financial professionals in the best position to meet these requirements that we're discussing today and ongoing as they arise and as they change, and to make those recommendations, make all these recommendations in the best interest of your clients. So in doing that, we'd like to invite you to reach out directly to me and have a conversation about our pilot program when it comes to our rollover analyzer. Again, getting you and your professionals in the right place. Will include ongoing collaborative sessions, ongoing webinars and roundtables, as a lot of you have already participated in and as are today. And again, that goal is to meet those regulatory deadlines as they arise, particularly as we discussed today for PTE 2020-02. So again, we're going to share this information. Please feel free to reach out. Thank you again. Param, I'll pass it back to you in the panel here.
Thank you, Travis. Let's move on and move forward to our Q&A session. I've got a long list of questions, and let me just start from the top. Does the fiduciary disclosure go to just ERISA accounts or all IRAs?
The fiduciary disclosure would also go to IRAs if the advisor felt that there was possibly a prohibited transaction. And the way that works is the prohibited transaction provisions that are in ERISA, there's a parallel set in the Internal Revenue Code that applies to a definition of plan in the Internal Revenue Code, which includes IRAs. So if there's a rollover recommendation or a transfer from one IRA provider to another, or from a let's say a brokerage account to a managed account, then there may be a prohibited transaction there. And if the exemption is used there, you have to admit that you're a fiduciary in order to comply with the exemption. But it's a fiduciary to the IRA, not to the plan.
Got it. There's one more question related to this, or maybe tangential to this, Carol. Is there a distinction in how firms should be documenting between recommendations to roll over from a plan to an IRA, and I guess from a plan to from an IRA to another IRA?
Sure. I have seen just so far, just in talking with clients, that I'm seeing it done. Some of our clients are doing a completely different format or form for the IRA to IRA than they're doing for the plan to the IRA. And I think that has to do with what they want their professionals to be looking at, what they want them to be comparing, because there's a lot less, I think, to going from the IRA to the IRA in terms of differences than there is like with a plan to an IRA. So maybe they have a short form or something along those lines.
Got it. Okay, we've got another goodie but toughie. How do you define the term recommendation? This might sort of does it need to be actually stated, I recommend you roll over your assets, or does something else trigger what is considered to be a recommendation? This is a deep one.
Yeah, and I laughed because this week I saw a report of a high-up person at DOL who was out at a speaking and who answered this question and said, no, you don't have to use the word rollover. Anything that has the effect of a rollover, where we consider that a rollover, because apparently that has been something at least that he got wind of, and he put a stop to that. So while that's not official, this is a pretty high up person at DOL who's kind of an architect of much of the fiduciary rules, and that was his statement.
Yeah, I mean, from an SEC perspective, when they adopted Reg BI, there was a bit of discussion in the Reg BI adopting release regarding the definition of recommendation for purposes of Reg BI, and what the SEC did in that circumstance was defer to the wealth of guidance that FINRA has issued with respect to when a communication rises to the level of a recommendation. So they didn't add anything on top of that guidance, and they said that we'll interpret Reg BI's applicability to arise consistent with that historical FINRA guidance. And really, it's a facts and circumstances test that is dependent upon whether there's a call to action. And I would agree with Carol's statement right now. There doesn't have to be a specific formulation that says I recommend a rollover. It's it's about the context and whether there has been essentially a call to action for the investor to make some sort of investment decision.
This is really key. Sorry, go ahead, Carol.
No, I was just going to say at this point, we don't have the, there was a lot of controversy in the last round between what was a recommendation for SEC purposes and what it was for DOL purposes. And there were a lot of really lengthy kind of hoops and if this, then that sort of thing. And we don't have anything like that now.
Yeah.
Oh.
Yeah. Speaking of which, this is actually a good / tough question. What is the definition, if you look at the 5-part test, what is the definition of regular advice? Has that been clarified out there?
No, the regular advice it's a facts and circumstances test, and it had not really been defined before. Until the DOL came up with this interpretation, it was just, I guess you assumed, well, there's some number more than one, right? It can't be regular if it's one. So, it's different. I suppose you could go through case law and see how different courts have ruled here and there, whether something was regular basis or not. But it was the standard if there was an ERISA fiduciary lawsuit as a standard at motion to dismiss stage would be, I'm not a fiduciary. I only talked to this person once, and that's pretty much how everybody got out of it. There was a remark from the same DOL official about perhaps regular basis doesn't mean numbers. Maybe it means something else. And I thought that was a bit of a stretch, more like, if you're trusted, then somehow that's regular. I didn't quite understand the logic, frankly, of what he said, but I kind of took that as a little peep into what we might be expecting when the new definition comes out. So, but right now I would say it's more than one, but I can't tell you much more than that.
The world of ambiguity. And speaking of
exactly.
Speaking of which, there's a really good question around where does education around rollovers stand today versus a rollover recommendation?
From a DOL standpoint, there was an advisory opinion that came out many years ago, and it's the Desiree opinion. You may have heard people refer to that. And what it said was basically, if you're already a fiduciary to the plan and you make a rollover recommendation, then that's fiduciary investment advice. And if you don't, then if you're not already a fiduciary, then it can be more education. And the DOL has specifically overruled that and said, this is our new interpretation, and we've rescinded that opinion. So you don't have to already be a fiduciary in order to be considered giving advice versus education. The last round had very, very complex, detailed rules on what investment education was versus advice. And, if you had certain models and if they had this or that in it, then they were advice, otherwise they were education. And now we just have a much more simpler kind of test that we went back to that at least is in effect now, that just says if it's not specific and it's just kind of general education, then you're in the education world versus the advice world. So it's really a facts and circumstances, and whether it's individualized is really what's key.
Yeah, I mean, I'll be really quick because I know we only have like 1 minute. You know, there's a bit of discussion in the SEC's Reg BI adopting release regarding the circumstances under which a communication would be deemed, you know, educational material as opposed to a recommendation. I would point you to the discussion within the release itself. It talks about very specific types of communications and examples of what would fall within the realm of education. It starts at the section of the release associated with footnote 179. So start there and keep reading.
That's probably going to work out on my end too for DOL. Whatever's in footnote 179, it would probably provide guidance.
Yeah.
Okay, Carol, Issa, and to our lovely audience for engaging with us today. Thank you very much for your time. We have a few outstanding questions, so I'll regroup with our panelists today and try to get back to you. We have your names and respective titles and email addresses, so we'll be able to come back to you with any responses that we may not have addressed throughout today's conversation. And with that, thank you all for your time and your attendance today. We look to continue to engage with you on a going forward basis. Kind of waiting for that number to drop, the number of participants to drop